Introduction. Procedural law. Procedural law. Law can be divided into two groups. Substantive law. Number two. Adjective or procedural law. Procedural law. Law can be divided into two groups. Substantive law, and two is adjective. Adjective or procedural law. Procedural law full stop, whereas substantive law determining right and liability of a party. Adjective or procedural law prescribe the practice, procedure, and machinery for the enforcement of those right and liability. Those right and liability full stop in Hals- Halsbury law. Halsbury Halsbury law of England. It can be it can be stated, there is at the outset a battle and outside a battle. There is the outset a battle and essential distinction between substantive law and procedural law. Substantive law and procedural law full stop. The function of the substantive law is to be define, create or confer substantive legal status over to impose and define the nature and extent of legal duty. Full stop. The function of the procedural law is to be provide the machinery over the manner in which the legal right or status and legal duty may be enforced or recognized by a court of law or other recognized or property constitute tribunal. Properly constitute tribunal. Full stop. Procedural law prescribe procedure for the enforcement of the right and liability. Full stop. The essence of substantive law is to a large extent depending upon the quality of the procedural law. Full stop. Unless the procedure is simply expanded and inexpensive. Substantive law, whoever good are bound to fail in achieving their object and reaching the goal. Full stop. Reaching the procedural law. Procedural law is thus in adjacent or in accessory to substantive law. Substantive law full stop. Two branches are complementary to each other and interdependent, and the interplay between him often conceal what is substantive law. What is substantive law and what is procedural law? What is substantive law? What is procedural law? Full stop. It is procedural law which put life into substantive law by providing a remedy and implement the well-known maxim UBI jus IBE remembrandum. Full stop. The Indian Contract Act, the Transfer of Property Act, the Industrial Dispute Act, the Indian Penal Code are instances of substantive law, while the Indian Evidence Act, the Limitation Act of the Code of the Civil Procedure and Code of the Criminal Procedure are instances of the procedural law. Instance of the procedural law. Full stop. The Code of the Procedural Law is in adjective law. Code of the procedural law is in adjective law. Full stop. It neither create nor take away any right. Full stop. It is attempt to regulate the procedure to be followed by the civil court. Followed by the civil court. History of the court. Before 1859, there was no uniform code of the civil procedure. Before 1859, there was no uniform code of civil procedure. Full stop. There were different system of the civil procedure in different part of the country. Full stop. The first uniform code of the civil procedure was enacted in 1859. Enacted in 1859, but full stop. But that code was also the code was also not made applicable to the Supreme Court in the presidential town and to the presidency small close court. Full stop. Some amendments were made therein, and in the code was applied to the whole of the British India, but there were many defeats in it, and therefore a new code was enacted in 1877. Enacted in 1877, again another code was enacted in 1882, which was also amend from time to time. Full stop. In 1908, the present code of the civil procedure was enacted. Full stop. It was amended by the two important amendment Act of 1951 and 1956. On the whole, these code work satisfactorily through. There were some defeated in it. Full stop. The Law Commission in its various report made many recommendations, and after carefully considering him, the government decided to bring forward the bill for the amendment of the Code of Civil Procedure 1908. Code of the Civil Procedure 1908, keeping in view inter alia the following consideration: a legitimate a litigant should get a fair trial in accordance with the expected principle of the natural justice. A litigant should get a fair trial in accordance with the accepted principle of natural justice. 2. Every effort should be made to expedite the disposal of the civil suit and proceeding so that justice may not be delayed. 3. The procedure could not be complicated. The procedure could not be complicated and should be the at most extended possible. Ensure a fair deal to the poorest section of the poorest section. Poorest section, the community who do not have the meaning to engage a pleader to defeat their case. Some of the important changes made by the Amendment Act 1976. Amendment Act 1976 are has under number 1. Doctrine of Rejudicia. Doctrine of Rejudicia is being made more effective. The doctrine of Rejudicia is been made more effective. Full stop. Power to transfer procedure from one high court to another is given to the Supreme Court. Full stop. Third, freedom from the attachment of a portion of the salary to all salary employee is granted. Full stop. Provision of the given notice under Section 80. Provision of the given notice under Section 80 before the constitute of a suit against the government or in a public officer is made less stringent. Fifth, restrictions are imposed on the right of the appeal and revision. 6. Provision are being made to ensure that return statement and document were filed without delay. Full stop. 7. New Order 32A. 32A has been inserted to provide a special procedure in litigation concerning the affair of a family. Full stop. The practice to be passed primarily and final degree in certain suit is abolished. 9. Scope of the summary trial is substantial with intent. 10 important changes have been made to provide relief to poor section of the community. Poor section of the community. The amendment made in 1976. Amendment made in 1976 were not found sufficient. Full stop with any view to dispose of the civil case. Expeditious Justice Melimath Committee. Melimath Committee was appointed by the government. Full stop in pursuance of the recommendation of the committee. The code was amended by the Amendment Act of the 1999 and 2002. The important amendment made by the Act of the 1999 and 2000 may be summarized thus in cervical matter. In cervical matter, thus a summon, filing of return statement, amendment of the pleading, production of the document, examining of witness, prosecution of the justification, preparation of degree extra. A time limit is prescribed also. A new provision for the settlement of the dispute outside the court has been introduced. Number of the adjournment has been restricted. The number of the adjournment has been restricted. The number of adjustment has been restricted for a provision for recording of the evidence by the court commissioner has been made. Fifth, endless argument are sought to be shortened by empowering in court to be fix a time limit for the oral argument. Time limit for the oral argument. Okay, time limit for the oral argument. Time limit for the permitting written argument to be placed on record by the party. 6. A provision is made for filing of appeal in the court which pass the degree, constituting the appeal against in the judgment is allowed where the degree is not drawn up. Scope of the first appeal, second appeal, later patent appeal and revision has been crucial commencement. The Code of the Civil Procedure 1908. The Code of the Civil Procedure 1908 5 of the 1908 came into force with effect from 1 January 1909 while the Amendment Act 104 of 1976 came into force with effect from the 1 February 1970. It may be stated that the Code of the Civil Procedure Amendment Bill 1974 was passed by the Parliament on the 23 August 1974. Full stop which received the assent of the President on the 9 September 1974. It became Act 104 of the 1974 and came into the force from 1 February 1974 except Section 12, 13 and 50. Section 12 and 50 came into the force on 1 May 1977 and Section 13 came into the force on 1 July 1977. The Code of the Civil Procedure Act 1999 received the assent of the President on 30 December 1999 and came into the force from 1 July 2002. Full stop. The Code of the Civil Procedure Amendment Act 2002 received the assent of the President on 23 May 2002 and came into the force on the 1 July 2002. Consolidation and codification. The preamble of the code state that the object of the code is to be consolidate and amend the law related to the procedure of the Code of the Civil Judicature. Full stop. To consolidate meaning to the collect all of the law related to a particular subject and to bring it down to date in order that it may form a useful code applicable to the circumstance existing at the time when Consolidate Act is enacted. Consolidate date is enacted. Consolidate date is enacted.